What is this area of contract law? Contract law is a very important component of the legal regime. We have an Indian Contract Act which was sparked by the English, the later part of the 19th century. What is a contract? A contract typically is an agreement between two individuals to basically honor some commitments. It is not just commitment, there is a very clear cut give and take. According to the law, a contract has got three components: an offer, an acceptance, and a consideration. Much of what we do in life has got in it some kind of implicit contracts. And though we don't fully understand that, there is an offer, there's an acceptance, and a consideration. Consideration means a payment. However, there is a gratuitous contract. A gratuitous contract, I think I pronounced the word right. Gratuitous, where there is no consideration, you're giving something to someone without any consideration. It happens at points of time in life. Now, let us see one or two examples generally in the normal course of life where we are invariably into some kind of a contract. When I hire a taxi, I have a contract. He offers a service, I am paying for it, and he has to take me from one point to another point. There's a contract, and he has to abide by it. Today, even oral contracts are valid. If someone can prove there was an oral contract. The, the one of the most important aspects of contract or contract law is to prevent breach of contract. Every taxi driver or auto driver knows that he is under a contractual regime with the public and he cannot breach it for any reason. There are sometimes auto people who take you in some cities and then they don't take you to the final destination. They drop you somewhere in between for some reason, citing some reason. It is definitely a case of breach of contract, which has to be punished, and it can be, and he has to give compensation for not honoring the contract. When I have breach of contract, there's one more thing called anticipatory breach of contract. Under certain circumstances, I am able to predict that some person may not breach, may not honor the contract fully, and I can take remedial measures saying that there is an possibility that this person cannot honor the contract. I can recontract a contract with the agreement of the people involved in a contract. At the end of the day, contract is an agreement, has got an offer, it has got an acceptance, and it has got a consideration. I can recontract a contract when I understand that, mutually understand that certain things have come midway which prevents in the proper execution of the original contract, so I recontract it. Now, under the overall aspects of contract law come various kinds of definitions and various kinds of special conditions. One of the aspects of it is capacity to contract. Another aspect is undue influence. And another contract is null and void contracts. And the modern day, I've got international contract regime where we talk of e-contracts, contracts which are conducted on the internet or the electronic platform. The law definitely defines the word called capacity to contract. Now, what do we mean by the word capacity to contract? That means a man must be technically proved to be of a sound state of mind and must totally and fully understand what are the implications in the contract. A man who is of an unsound mind cannot be in, cannot get into a contract. A minor who does not understand what the contract is suo moto cannot enter into a contract. He can enter into a contract with the help of a major who explains to him what is the contract, because a minor does not have capacity to contract. Now, these are all aspects, because if a contract is entered into a person by a person who has not got capacity to contract, sometimes that cannot be treated as a contract at all. We have contract laws because it gives relief and damages in case the contract is not properly honored. We have the world and the society at large works under the uh, what we call, or works under various kinds of contracts, or what's or otherwise said, in the absence of contracts there is no economy, there is no trade, there is no momentum for economical activity, or even otherwise. Now, contracts have got another aspect called as undue influence. When I say undue influence, I cannot unduly influence someone to enter into a contract. Undue influence can come between a parent and a child, it can even come between a student and a teacher, or it can come across various kinds of other forms of stereotype social relationships. Undue influence can be carried out in various ways. A person can be deceived into entering a contract, which also means is undue influence. So this is another aspect of contracts where I try to understand various forms of undue influence, if at all, in any given given contractual situation. If a contract were to be legally challenged, if one of the parties concerned can prove that I came under the influence of undue influence, then the whole matter can will be looked from a different dimension. Undue influence can also mean was I under the influence of some alcohol or so deliberately by someone made to sign a contract. If I can prove such an eventuality, the contract per se may not be fully operational. The contract regime tries to protect the faith, the good faith. All contracts must be done under good faith. Bona fide. It cannot be done in any aspect of bad faith. Now, these two, I dwelt upon two concepts, ideas of contracts and contract law regime. I can have null and void contracts, contracts that go against social fabric, contracts that are damaging to the community. Such contracts per se can become null and void. Null and void contracts also can happen if a contract has got a specific time period during which it has to be executed. And if for any reason the whole aspect has gone beyond that time period, that contract at that becomes null and void after that given time period. There's one more aspect of contractual regime. No third party has got any say in any given contract if he is not implicit to the contract. That means I cannot challenge a contract entered into by another party and until and unless otherwise stated. The relief must be claimed only by the person who is party to that contract. I've got many such kind of terms around which contractual law works. What would be the other aspect? Very often there's a law of tort that also is sometimes seen under the overall contractual law regime. Law of tort is unwritten social contracts of civil right. In any given situation, as a reaction to an event in society, a human being is expected to act in a right and constructive way. Tort means a wrong. The opposite of tort is rectum. For example, if I find a man, someone who was met with a small accident on the road, I cannot walk away just like that. The unwritten civil contracts ensures that at least I must call the police and tell that there's an incident like that, then he be helped in this matter. Otherwise, it comes under what is called as tortious liability. In some societies and communities, the law of tort is taken very seriously by the legal regime to see if someone has not done the right course of action called rectum in the event of some eventuality. Comes under tortious liability. Now, coming to the modern day world and the entire domain of contracts. Today I've got a globalized world and where we have got e-contracts. The problem with electronic contracts is the concept of asymmetry. Contracts which are asymmetrical, which fundamentally means that what is stated and explained by one party might be understood in a totally by another party in another country, creating to confusion and friction. And in this aspect of e-contracts, sometimes people don't meet each other. They only interact on the media like internet. And I have to be careful that contracts are brought to a symmetrical level and there is no asymmetry which is very much possible in international e-contracts. So we just touched certain things about contracts. What is a contract? Capacitor contract, undue influence in contracts, null and void contracts, law of tort, and finally we had an idea about asymmetrical contracts or international contracts or e-contracts. Hope this has helped you to understand contract law as a beginner.